with the actual business. So my name is Andy Levy. I'm a trial lawyer from Baltimore. I also teach at both of Maryland's law schools, and I am joining you from a little town called Highland, which is about halfway between Baltimore and Washington, D.C.
Morning. My name is Chuck Dunlap. I'm Executive Director of the Indiana Bar Foundation in Indianapolis, which is where I'm joining you from, albeit my home. This is obviously not my home office, but my virtual background, as much as a congressional hearing as we could get. And I'm also an adjunct professor at Indiana University and looking forward to talking with you today.
Good morning, Massachusetts. My name is Caitlin Johnston. I think we've met before. It's nice to see you again. I am joining you from New York City in my studio apartment, and my day job is I'm an in-house attorney at Peloton Interactive, a fitness company. And my history with We the People includes participation as a high schooler back in Indiana, but I never made it to nationals. So congrats on getting here and good luck.
So please introduce yourselves.
Good morning. My name is Jonas Saheka, and we're all juniors at Easthampton High School.
Hi, my name is Alice Wanamaker.
My name is Anwar Zabir. This is our teacher, Ms. Brown, and our mentor, Hannah.
Okay. One of the hazards of getting as old as I am is it gets difficult to tell the students from the teachers. So thank you very much for letting me know that. So I'm going to read the question, even though there's no mystery as to what it is. And then as soon as I do that, you're welcome to start. So this is Unit 5, Question 2. Richard Posner wrote that the American public worries more about invasions of privacy than about summary proceedings against suspected terrorists, curtailments of the freedom of speech of the law-abiding, or the right of the media to publish government secrets. Do you agree or disagree with this statement? Why or why not? To what extent, if any, is privacy in jeopardy today? What protection, if any, do people have from privacy violations by governments or businesses?
Richard Posner argues that there are
You can go ahead.
Richard Posner argues that there are two basic forms of privacy with which people are concerned: being free to go about one's business with minimal interference and to not have personal information used against them. Yet, neither the Constitution nor the Supreme Court has clear provisions protecting either. We agree with Posner on this. Posner argues that the existing privacy zones created by the court and are most debated are not the most important nor the areas most at risk. We disagree with Posner that issues of abortion and sexual privacy are not a significant concern to many Americans, but agree that the Supreme Court needs to better address privacy as a fundamental right in both the public and private spheres.
The problem with digitization is that so much data is collected, it's nearly impossible to opt out of disclosing it. We believe that the third-party doctrine established in Smith v. Maryland is outdated, and that the word voluntary can no longer apply. As Justice Roberts articulated in Carpenter v. U.S., when Smith was decided in 1979, few could have imagined a society in which a phone goes wherever its owner goes, conveying to the wireless carrier not just dial digits, but a detailed and comprehensive record of the person's movements.
Well, the court has acknowledged in Kylo, Jones, Riley, and Carpenter that today's digital world is completely different from the 1970s. They continue to adopt the same tools, which Posner argues is trying to put a square peg in a round hole.
Privacy is in jeopardy across the world today because people must give up their private data to operate in society. DNA, cameras, digitization of data, and the collection of vast amounts of data by public and private organizations leaves open the possibility of deep intrusions into people's lives and the misuse of data. Today, new police technologies that the founders could not have dreamed of already in the Fourth Amendment, such as infrared sensors, GPS, and stingray mimic devices, all pose a challenge to the Supreme Court that constitutionally protect privacy.
The passing of the Patriot Act legalized intrusions into people's most private places and papers. Section 702 allowed for surveillance and collection of data unknown to Americans. Section 215 allows the government to acquire secret court orders requiring third parties to hand over records. Nearly 20 years after September 11th, Congress is rethinking these broad powers and is working to pass further limits on government surveillance of American citizens and to create further checks on the FISA courts. The protections we have from our government are very limited and not expressly stated. Federal and state government officials are limited by the First, Fourth, Fifth, Ninth, and 14th Amendments. State governments provide extended limitations on police beyond the Bill of Rights. For example, the cell phone location data in question in Carpenter v. US would have required a warrant in Massachusetts.
There are even fewer privacy protections provided by businesses. Special relationships with lawyers, doctors, and financial advisors provide some privacy for our most personal data. Companies have collected consumer data for years, but Posner argues that increasing digitization allows for mass accumulation and centralization of data, which poses a significant threat to privacy.
Most protections from businesses are voluntary to avoid distrust in customer laws. For this reason, Congress and other government officials use avenues like the hearing process to bring light to consumer protection issues.
Posner argues, and we agree, that some major changes should be made to protect the privacy of Americans. First, people should be able to own their digital data away from companies' hands. Second, courts should stop trying to reshape the Fourth Amendment and establish a fundamental right to privacy and data, as it would pass both prongs of the substantive due process test. Privacy is clearly grounded in historical tradition and fundamental to ordered liberty.
As argued by Posner, if liberty in the Fifth Amendment's Due Process Clause can connote sexual freedom, the court should be able to establish a fundamental right to privacy, especially to protect and control our own data. Thank you, and we're ready for your questions.
Okay, well, thank you for that. Let me remind you to put away your notes, which we're supposed to remind you, so I've done that. Are you troubled by the fact you characterize privacy as a fundamental right, and you have an interesting construct for how it satisfies that. But are you troubled by the fact that it is not expressly protected in the Constitution or the Bill of Rights, and that by making it a fundamental right, you would give enormous power to judges to shape what this fundamental right is?
Well, I believe that, so what we have today to protect our privacy is the Fourth Amendment, which says it protects unreasonable search and seizure, but we also have this idea of a reasonable expectation of privacy, which was established in Katz v. US, and later, which the idea was established in Olmsted, and it later established in Katz v. US and by Justice Brandeis. And so I think that this idea of a reasonable expectation of privacy, while it does pose some privacy, I think that making it a fundamental right would really put it into place and ensure that it's not violated in today's world.
For me, I think that the most important part of creating a fundamental right, for example, to own your own data and decide how it's used by companies, is the ways that it would be held to a strict scrutiny standard.
So I'm sorry, let me interrupt you. So you would apply this fundamental right not just to limit the power of government, but to limit the power of private actors. Is there any other right that is interpreted to limit the powers of private individuals?
So I think you're talking about the state action doctrine there, which basically states that these fundamental rights apply to the government, but not to private businesses. But we're generally in opposition to the state action doctrine. Personally, I think that it was created as an excuse for the court to nullify amendments they were uncomfortable with. We can see that in the civil rights cases in 1883, kind of nullifying the Equal Protection Clause of the 14th Amendment and forcing the legislature to pass the Civil Rights Act nearly a century later. So I think that this issue with it applying to private businesses, as you said, could be solved in one of two ways. It could be solved with legislation supporting it through the Commerce Clause, Article 1, Section 8, Clause 3, or it could be solved by an amendment or a fundamental right explicitly stating that it applies to private businesses.
Well,
Yeah.
I'd agree with the outcome, but I'd have to disagree with the way we go about it. I don't think we could do it through the legislative process or the judicial process. The legislative process would rather argue way too much with each other due to being in opposition in different parties. So they would not come to an outcome very quickly. So it would take way too long. The judicial process has two different ways they go about it, and I don't think that they will come to an agreement on how to solve it. I think that the way we should go about it is kind of what Justice Brandeis articulated. he said that we need to look at the states as the laboratories of democracy and kind of try out legislation in one place and then see how it goes about throughout the country. I think currently today we're kind of seeing that with California's Consumer Privacy Act, which states that people have a right to be forgotten, a right to know what information is being stored, how that information is being used. And I think just by looking at them, we can see that we need an act like that. We need our own states to kind of step up and be the laboratories of democracy today.
I want to go to another question. Current COVID-19 emergency situation that we find ourselves in, the idea of preserving the public health and using public safety government's perspective for contact tracing and tracking movements and things like that. How do you think courts should handle that versus the inevitable invasion of privacy issues that come with that? How should they balance those? And is there precedent for how they should handle this?
Well, I think that we can see increased violations of privacy in a few different ways. We can obviously see increased use of technology, social media. You have to give up some rights in order to participate in society in the world today. You can see drone surveillance starting in China, but now coming into the United States and Florida and New Jersey. But I think that because we have a compelling state interest, this actually should really. A lot of these violations of our privacy are okay as long as they're doing it in the least restrictive manner. So I think that that's really like why it's being able to happen in a way that may appear that it's restricting some of our rights.
Do you think that once we've gone down this road, that the government is going to give back those? Are circumstances going to change where what is okay now is not later? I should probably turn it over to Caitlin because she needs to get her question in.
That's fine. They can answer that one.
Okay.
I think that the coronavirus pandemic is really showing just how crucial a fundamental right could be and how crucial the strict scrutiny standard could be, because the government has an outsized compelling state interest in surveying us in order to keep us safe right now, but the least restrictive manner requirement could help keep us safe in the future. And scholar David Hudson agrees with me that one really important point of that could potentially be forcing the government to later erase a database that they created right now.
So
Thank
would
you.
the panel be okay with Apple sharing all of our GPS location data with the police and letting the police ticket anybody who's not socially distancing?
I think the sad fact is Google can do whatever it really pleases. I think that when we kind of sign up for these apps and we put our emails in there, we kind of sign these terms and conditions, which kind of waive away all of our rights. And it states that these businesses can actually change their terms and conditions at any time if they violate your rights, to kind of keep up with that. So I think that Google, while it can give out your GPS location to the government, I don't think it should. This is why I truly think we should overturn the state action doctrine and actually have legislation that applies to these businesses, doesn't let them get away with violating our rights. We can see that even Zoom in and of itself actually.
That's time.
I have to stop you there because it's time, but
Sorry about
I would have loved to have let you go on, believe me. So.
Oh.
So let me start out just with some comments. Wow, that time went quickly, which is really an indication of just how good you guys are and how interesting what you had to say was. And I had really a million questions I would have liked to have asked. But wow, guys, it was a brilliant opening. It was very interesting. It was substantive. Lots of interesting references, but it wasn't. I never had the idea you were just, reading a list of stuff. There was a coherence to the opening, and a structure to it that was very interesting. And then, so what's going through my mind as I'm listening to it, I thought, well, I'm going to really test these guys. I'll ask them a question and see if they really understand what it was they were just telling us. And, I just got to say, for the most part, you hit it out of the park. I'm not sure that the use of a constitutional provision to bind private, the power of private entities necessarily would withstand sort of extended sort of analysis, but it's a very interesting question. And I just thought, and then I guess Alice, was you sort of pivoted right to the state actor doctrine, and really great. I mean, I would, if I had my law students able to sort of have a discussion like this on this plane, I would felt like I died and gone to heaven. So really just first rate in every way.
Yeah, I will agree with what Andy said. And the other thing, just the reason we could have this conversation is because your level and depth of knowledge was so deep and so strong. You covered things that, one of the things you had a lot that we packed in just because time is, of course, of the essence. But a couple things that I thought were noteworthy that I hadn't heard from yesterday, from a similar discussion, the idea of state governments, and you didn't ignore that. And you talked about state governments with a higher level of protection, which of course they can provide. And the class I teach not law school students, but I teach a lot of undergraduates and kind of an intro to law and public policy. And I stress that all the time. I could have you guys come in and guest lecture because it was so good. The other thing that I really enjoyed was, even in your discussion when you're talking about various things, you didn't say strict scrutiny necessarily. Oh, you did sometimes, but you used the standard and you used those things. It wasn't just a perspective of, you pulled in the court, the standards and things. It wasn't just my opinion is. You backed it with a lot of really good information, and you had specific proposals. That's a level of depth that, frankly, is extremely impressive, and you should be extremely pleased with your performance today.
Yeah, and to build on that, giving proposals is somewhat easy, but when you do it with all of the foundation that you all brought, particularly in follow-ups when you don't know what question's coming at you, I just thought it was super impressive. We love to see students pull out new information that they didn't cover in their prepared remarks meaningfully in follow-ups, not just to kind of like drop a case name, but to actually tease it out. And you did that beautifully. I also liked the proposal to look to the states. That's not something we've heard from a group yet. And when the COVID-19 outbreak hit, my team on the legal team at Peloton is analyzing 50 state laws and trying to figure out, is it a violation of federal privacy laws that in Ohio now we have to take our employees' temperature at the door before they're admitted to the workplace? Is that a medical exam? And so it was really, really interesting. You pulled in CCPA. That was very, very impressive how you kind of tied it all together. So excellent job.
Thank you.
So a shout out to, first of all, what great work, obviously, from your teacher and your coach. But the other thing I'll say is one of the sort of miraculous that we're able to sort of do it in this forum. But one thing we miss is when you're with us in person, we get a chance to be with your parents and see your parents. And so please just tell them how impressed we are with these young guys that who have obviously all an enormous future. So thank you, goodbye, stay safe.